We're ready to get started. I'd like to call the commission, the Value Adjustment Board meeting to order. Would the staff call the roll? No? You don't have a roll?
We'll go through and do introductions.
Oh, okay, we'll do that. I don't see an agenda here, so I didn't know. Yeah, okay. You give it to him. He's gave me his. All right, good. Now I have an agenda. Excellent. All right, we'll begin with the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Okay, item C, ratify legal counsel.
I can briefly speak to this.
Okay,
This is
all right.
required to be the first action item on the organizational meeting agenda. I know that the staff has proposed myself to continue as legal counsel. The terms are unchanged, other than the time frame, and they've been significantly the same for the last few years.
Okay, any questions? I know at the last, not the last meeting, but maybe 2 meetings ago, we ratified your contract at that meeting. I assume that was for a year. What was,
I believe that was for the interim period,
okay,
so to bridge the gap between the end of the last cycle and today, basically.
okay, all right, so that was more of a bridge agreement. Okay. All right, is there a motion to?
Move to approve.
Move to ratify legal counsel. I guess second. Any discussion? All those in favor signify. Can we just vote as a group? We don't have to do a roll call vote. Okay. All those signify by saying aye.
Aye.
Aye. Opposed, nay. Passes unanimously.
Thank you.
Okay. So now we'll do the introduction. Now we appointed myself as chair at the last commission meeting, but I had a question about that. Does the Value Adjustment Board need to make that decision, or does that come from the commission?
It does come from the commission.
Okay, so I'm the chair.
All right.
I was volunteered for that.
Were you at that meeting when they did
I was there.
it? Because usually they like to choose the person that's not there.
And Commissioner Atkinson's our vice chair. Do we have a vice chair? Does it need to be a commissioner, or can it be anybody?
It does have to be a commissioner,
It does have
and it
to be
also would be appointed by the commission. There does not
a
have to
county
be one.
commissioner, but not, okay.
Yes.
Well, you're the only other. Okay, good. All right. I don't think you have much of a choice, do you? No. Okay. So I'll introduce myself, Thad Altman. I'm County Commissioner of District 5. It's a great honor to be a part of the Value Adjustment Board. I think we have a very important role in the process. We have a great appraiser that we work with, and a great county. It's always interesting. Looking forward to a new year and a new tax roll. And we'll start next with our Vice Chair.
I'm Kim Atkinson. I am County Commissioner of District 3. And I'm actually kind of interested and excited about the VAB. That's all for me.
Matt Susan, Brevard County School Board, District 4.
Okay.
Hello, Rob Adams, a resident of Indian Harbor Beach.
I'm Bob Springer. I'm retired and I'm a resident of Merritt Island.
Aaron Thalwitzer, I'm legal counsel.
Okay. We should have you guys introduce yourself and your role.
I'm Jason Arthur, Chief Deputy Clerk's Office.
Kim Powell, to the board. There's also a clerk of the board.
Great. Well, thank you for your support that you give us with the clerk's office. Yeah. Okay. It says, provide contact information of VAB members and clerk staff. What does that mean?
That's,
all provided this,
Oh, this is it, right here. Okay, it's been handed out. Okay. So
and it's on our website as well. We all have
you've got all the contact information. All right, excellent. Now, that said, I'm sure we have thousands of people watching this exciting meeting online. That said, we are prohibited from speaking, if somebody contacts us about a VAB issue, we are not allowed to talk. We can't have ex parte communication, can we?
if it's about a specific case, absolutely, that's correct. If it's a general VAB concern, then, yeah, you can speak about that.
And what would be a general concern?
Maybe the rules that the VAB
Right.
has passed, could be any of the issues really at today's meeting, because none of them pertain to specific cases.
But specific cases, somebody calls us about their assessment, we can't talk. What if, just hypothetically, let's hypothetically say somebody knows they're going to appeal, but they haven't done that yet, and they want to talk to us about it. Now, my gut instinct is no. What,
That would be my instinct as well.
go talk to the property appraiser.
I would point them to the clerk,
Okay.
actually, if they have a, maybe a procedural question. Before anyone connected to the VAB, myself, the board members, or the clerk can discuss anything substantive related to a petition, or I would be cautious and say a potential petition, I would at the very least want the property appraiser to be in the loop and a part of that communication.
Okay, excellent. Okay. All right, next we have the minutes. I need a motion for approval of the April 25th,
Move to approve.
May 5th, and May 12th minutes. A motion for approval, is there a second?
Second.
Second by Commissioner Atkinson. All in favor, signify by saying yea.
Yea.
Opposed, nay. No opposed, passes unanimously. Okay, and we're okay that we pass those three amendments as a block? New business, appoint special magistrates, 2025 tax cycle, VAB Council memorandum are referenced special magistrate applications.
Yeah, I submitted memos regarding the special magistrate applicants. I believe all of the applicants this year were qualified, and most, if not all of them, have served the VAB in past years. I recommend a motion to appoint all of them. And that can be taken either all at once or separately between the three different types of magistrates.
Well, let's see if all at once works. If nobody has any opposition and they agree with that, a motion to approve all the applicants would be
Move to approve all applicants.
motion by School Board Member Susan, second.
Second.
Second by Commissioner Atkinson. Any discussion? All those in favor signify by saying yea.
Yea.
Yea, opposed, nay. Motion passes unanimously. Number 2, discuss memorandum reference to the legislative updates for VAB.
I'll cover that one, and this kind of leads into the next item as well. In between the last meeting and today's meeting, the legislature passed a bill which made some significant changes for the VAB. The one most relevant to today's meeting is increasing the maximum filing fee that the VAB can introduce or can adopt. For decades, it's been $15 per petition. The maximum has now increased to $50 per petition. So the board has discretion to adopt a filing fee anywhere within probably the range from 0 to 50, though a $0 fee was actually passed by a VAB, I believe, earlier this week or last week in Broward, which, to my knowledge, that has not happened in a long time, if ever. But the board does have discretion to pass whatever filing fee really it wants, up to a maximum of $50.
What passed in Broward?
A $0 filing
Zero.
fee. Yeah, I saw a grid with about 3 dozen VABs that have adopted filing fees since the new legislation. Most of them did go with 50. I would say maybe a quarter of them were somewhere in between 15 and 50. Broward was the outlier at 0. And a lot of them have sort of announced, this year we'll go with something like 25, 30, 35, with the intention of increasing it to the maximum next year. That can't be actually enacted now. That would have to be taken up next year, but they announced sort of their anticipated increase.
Question, Commissioner Atkinson?
My question is, the $15 that we take now, as a guesstimate, how much of our cost does that cover?
I don't know. I can tell you, I did see numbers from Volusia County, which has a similar number of petitions, very similar county in a lot of ways for the VAB. For Volusia, it was 10 or 20%,
That's all.
what the $15 fee would cover.
Okay.
But I asked that, we don't have those numbers handy today.
If I may, I was talking to our attorney ahead of time, and I asked him, I said, can we get a breakdown of our budget so that we can actually make a decision based on, is there a need to increase it or not? And he said that he would go work to get that to us. I also said, at what point do we need to make this decision? And he said, I think you said January 1st, we could have another meeting.
That was with a different rule.
Okay.
So if the board isn't comfortable changing anything today, what I would recommend is at least leaving the $15 sort of standard filing fee in place, and then if the board wishes to change that based on the information on the budget, another meeting can be set at any point.
I just personally, so everybody understands, not that a business owner or a homeowner or anybody like that doesn't have $15 or $50 to actually pay. I just wanted to make sure on my end that it was justified before I made a decision to raise it. Because we all, in government, people just start raising fees, and then the next thing you know what I mean? And our attorney had mentioned that the school board pays two fifths of the budget, and the county pays 3/5. So it seemed like there's a little bit that we could do to look at the budget and then make that decision. That's just me. That doesn't mean that that's not something you guys can move on, but that's just where my head was to evaluate it before we made that decision, that's all.
Chair? I was gonna say, my thought is that if the $15 covers only a teeny tiny portion of our expenses, it would be interesting to see the budget.
So that we
because
can see.
We might wanna
Yeah.
do something different.
Anytime we cost shift from the government paying for things to the people paying for things, and the percentage goes up, whether that's healthcare or whatever, there's usually some people that come back and say, hey, why'd you raise it? And I just need to be able to say, this is the reason, or we didn't raise it because of this reason. That's all. And I didn't have those documents in front of me. That's why that's what I mentioned.
Yes.
So-
Mr. Springer?
I believe of these petitions, there's a percentage, a significant percentage of no-shows. So the staff goes off and does quite a bit of work, right? No one's getting rich in this organization, but it's a significant outlay in capital for the county to do the work, and then there's a no-show, and that money goes away. I believe that raising the petition fee to 50 might make those petitioners more serious about
Yeah,
it.
good point.
And would cut down on your no-shows, if that's the right way to do it.
It's a good point. It is.
What, I'd be interested to break down how it's spent. I assume it goes toward our staff, legal fees.
Usually
Does any of it go to the property appraiser?
No, not at all. They don't contribute and they don't receive anything. The biggest cost is almost always the special magistrates, because
The
there's quite a few and they
magistrates,
handle all
yeah.
the hearings.
Is that
And-
$100 per petition, or?
It's hourly.
Oh, it's hourly.
And what did we get?
That's right.
I don't, 1,000 petitions roughly a year?
2,400 or so last year.
2,400, okay.
At $135 an hour?
About $45,000, yeah, so 45,000 is what we get with the fee. Yeah.
There are some exceptions, so it's probably a little lower than that, but yeah,
Right.
for rough math.
Okay, so petitions are going to be, when do they start filing? What's the date, the deadline, or when can you file a petition? What is the date?
What was the date? Is it, September?
They start filing petitions March 2nd, sometimes before that. And then they can file all the way up till the date that's on their term notice, which I believe is September 12th this year. And then after that, that's when the deadline is. Then it goes into good cause. They can still file petitions.
So we got a little time,
Yes,
if we wanted to.
the board would have to come back
I think it's
before.
fascinating taking a look at the budget.
We'll take a look at the budget and we'll make a decision.
But we'll have to have a special meeting to do so.
We'd have to have a special meeting to do so.
Could the board enact a $15 filing fee just in the interim, which it's been for 40 years or so? That way, we've at least got a resolution for
Yes.
what we're receiving now. I would recommend doing that. We are required to set a filing fee, and if we don't, it's a little ambiguous. Do we continue it from last year? Is there even a filing fee at all? So to avoid that ambiguity, I would recommend setting something today.
Sounds good to me.
Yeah. And I think, I don't know. I don't have an opinion of it, but I guess there's a couple way of looking at it. Keep not raising fees, but on the other hand, that might be $30,000 that might go to a teacher's aide in the school board, you know.
Well, and
That
County's
depend.
budget's pretty tight at the moment.
County budget's pretty tight.
to his point also, making sure that people actually apply,
That's a very good point.
you know what I mean?
Yep, you've been here, so.
That's a good point.
All right, we're good.
Can I make a motion then to keep the filing fees as they are for now until we discuss it at the next meeting?
That's a good motion
Yes.
by Commissioner Atkinson,
Second by Susan.
second by Susan. Good. Any discussion on that motion? All right, all those in favor signify by saying yea.
Yea.
Opposed, nay. No nays, passes unanimous. Great, thank you. Okay. The next item is item 4, E4, discuss and adopt resolution number 25-02, reference establishing local guidance for electronic appearances at hearings.
And this kind of relates back to one of the other legislative changes that occurred. It won't have a big impact on our VAB. Basically, in prior years, VABs were not required to allow electronic hearing attendance, remote attendance. I know we've had that for several years. I don't know how long it's been, but many years. So we don't really have to make any big changes, but I did draft up some local guidelines to make sure that we're compliant with the new law, which basically just says if a petitioner requests electronic appearance, we have to provide it. That's more or less the requirement. We have to provide procedures for electronic receipt of evidence, which are incorporated in those local rules. Again, on a sort of ground level, it's not going to change much about how the VAB does business because we've been doing electronic hearings during the pandemic. All of them, I believe, were electronic, and we've been receiving electronic evidence for a long time. So I don't think logistically it's going to create any new issues. But my recommendation is to adopt the local procedures, establishing those electronic hearing procedures.
Okay, interesting. So, any questions on that?
Just me.
Yes.
So by, how do I say this? By establishing the ability to have electronic hearings, I believe the intent is to say, we'll take care of the county side of the interface. The petitioner has to be able to, in other words, the county's not going to give the petitioner a computer to go do that kind of stuff.
Correct. The VAB is required to have the equipment needed, make sure that it's clear enough that it's accessible by
Right.
the parties and the public, at least in some way. It could be an in-person attendance by the public. It doesn't necessarily have to be electronic, but they have to be able to
Right.
attend in some way.
Does it state the operating system? In other words, if the petitioner has an Apple iOS operating system and the county has Windows,
It doesn't get that granular. I believe we do, is it just telephonic?
you can probably do both?
We just offer telephonic, which is compliant.
Okay.
We can
So
offer
We're not
video.
talking about Teams or
No, it's just a phone
or
call.
Zoom.
IT support for the petitioner?
Oh, it's just a phone, it's
And that's
verbal.
what, yeah, and that's what a lot of VABs do, not the
Oh,
video.
interesting.
Yeah.
Okay, thank you.
So if it's, you get no graphic interface, then
Right.
it's just a verbal, okay. Okay. Any other questions? I guess you need an action to accept those procedures?
Yes, a motion to
A motion would
adopt.
be in order to either accept, deny, or amend the procedures that are presented before us.
I make a motion to accept the procedures.
Okay, a motion to accept procedures as presented for us by Commissioner Atkinson, second by Matt Susan, school board member. Any discussion, any debate? All those in favor signify by saying yea. Yea. Opposed, nay. Passes unanimously. Okay. Okay, item E5, discussion regarding adoption of Robert's Rules of Order, newly revised for the VAB meeting, VAB Council Memorandum, and Robert's Rules. And any discussion?
No, as you guys remember, it was a good to
Yes.
adopt as a formal process. And just for clarification, on a small board, Robert's Rules of Order, a tie, the chair gets the, do you need that? Because that's not always clear. If you read regular Robert's Rules of Order, the small boards is usually a section of the Robert's Rules. Sometimes, whether we're a small board or not, is considered different ways. I would like to adopt it that if there is a tie, that the tie goes to the chair. It clears stuff up, because then you have a winning side rather than it didn't get a majority and it loses. You know what I mean? But that's up to everybody else. It's usually what small boards do, anything under 7. They do this just in case there's one member missing and we need to have it. But that's what I would suggest. We've had a couple times where there's 4 of us, and only one time was I questioning where it would go. So as part of this, I would like to have that as part of it. But I really appreciate you bringing it forward, because I think this gives us the framework. After we pass this, if there's a way you can get the Robert's Rules to our board members that may want it, you know what I mean, as a guide for them
Yeah,
to
if
read.
anyone wants a copy, just let me know and I'll
Yeah,
get
okay. That's my 2 cents, if it makes any sense.
Okay.
I'll move to approve it with those,
Conditions.
yeah, so I move to approve with the idea, move to approve the line item with the idea of adding the tie to the chair as part of it.
Is there a second?
A second.
Second by Commissioner Atkinson. Any discussion? All those in favor signify by saying yea.
Yea.
Yea. Opposed, nay. Passes. Now, there'll be a test at our next meeting.
For the elected members, not for the volunteers.
So maybe Matt Susan will be our parliamentarian, since he's the one that wanted,
There we go.
yeah, the rules chair. Okay, now, our tentative schedule for the upcoming VAB. We talked a little bit about that.
Hearings will start October 20th. We'll start with exemptions within the first 2 weeks, then move on to real property value, et cetera, the first week in November.
That's an easy schedule.
I think that's it.
October, November. Now, our fee, if we change the 15.
Would have to be in before October.
Before that.
Yes,
And what is the date when people will be filing those petitions? I mean, we have
they're
to.
already, they're filing as we speak.
And they're paying $15.
Yes.
So any change that if we wanted to do would not be in effect for the filings for the hearings that are coming up.
For the petitions already filed, they'd essentially be grandfathered in.
And we would have to probably make it to where it's after this year would be.
It would have to be after this year then.
Be a lot cleaner.
Yeah.
Okay, see a hand. Go ahead.
The clerk would ask that if the board were to increase the fee, that it be applicable just to the 2026 cycle.
Yeah.
Okay,
That's
gotcha.
it.
That answers a lot of my questions.
And I believe that would eliminate any specific start date or whatnot. It just
Right.
Petitions.
Okay, that's good input. So we're talking about next year, and we'll be meeting, hearing, give plenty of time to have discussion, since
Yep.
we'll be meeting. Okay. All right, so item E7, approval of VAB good cause decisions determined by VAB council.
These are petitions that are filed late, so the process there in the past has been, they go before myself, and I decide whether there's been the extraordinary circumstances required to allow a late petition to be accepted.
Are those set forth in statute,
Yes.
Mayor? Okay. So I guess the action we would need to take is whether to delegate that to you or have that come to us as a full body.
The options are to have counsel, the clerk, or an attorney special magistrate handle the good cause.
I got you.
I've handled it since I've been counsel, but it's at the board's pleasure.
Okay. So what would be the pleasure of the board?
When you review them, do you charge it by hour, or is that part of your fee?
It is by hour.
And then if the clerk does it, they do it by, right,
It's just part
Okay.
of the position.
interesting. Okay. I have no problem going forward with the way it was.
I make a motion to keep doing what we've been doing.
Okay, the motion is to continue the process by which we determine good calls, decisions, and have them, for filing late fees, have them determined by the VAB council.
Second.
Second by Susan. All right, any discussion? Any debate? All in favor signify by saying yay.
Yay.
Opposed? Nay. No opposition, passes. Okay, E8. Approval, VAB good calls reschedules determined by the VAB clerk and her designee.
And this is where a petitioner wants to reschedule a hearing. They get one good cause reschedule, sort of as of right. They still have to show good cause, but in the past, the clerk has handled that, which I think is the best idea. They handle most of the, all of the scheduling, so it just makes sense.
Okay. All right,
Move to approve.
there's a motion to approve. Is there a second?
Second.
Second. Any discussion? All in favor signify by saying yay.
Yay.
Opposed, nay. Passes unanimous. Thank you.
Can I ask real quick, after that, before we get to the next one, who holds the agenda for the VAB prior to the chair getting it? Is there, because normally you know how somebody is the holder of the agenda and then it gets published and then the chair has it for the last couple of days or something like that, usually 7 days to change. Is that in effect here, or how do we do all of that?
There's no procedure equivalent to what you're talking about. Really, the clerk prepares an initial draft.
Okay.
I
So
review it
clerk
and approve
houses
it.
the agenda. So if anybody wants to add to that agenda, they would go through the clerk, say, I would like to be on the agenda, and then that comes before us. Go ahead.
Yeah, if any board,
Then we'll contact either the VAB attorney or the chairperson of the VAB and ask their approval to put something else on the agenda other than what is specifically there.
Is that specific the whole time, or is that time-specific, meaning, do you call them anytime anybody tries to, or is it the last 7 days or the last 14 days? Somebody comes to you 2 months ahead of time and says, I'd like to be on the agenda. You make that determination and then call one of the attorneys or the chair then?
We wouldn't make the determination, we would ask.
Call.
or ask
So you're running that portion of the additions? Okay.
essentially,
Okay,
final word, I would say.
yeah, okay. And then if you think it might be something the chair needs to hear about, he'll do it. Is there an opportunity for the chair to look at the agenda and say, I don't want these on here? Or take them off?
That could be done.
Right, okay, I just want to make sure, that's all. Okay, thank you. Sorry, I was just curious because, I was looking at, thank you.
I think we'll make an effort to get the board the agenda
Oh,
as
yeah,
soon as
no.
possible. They have that option.
I've
to
never had
add
an
or
issue,
change.
nor do I
Right.
have any issue with anything here. It was just a
Yeah.
curious process question, that's all.
Okay. Did we vote on 8? Do we need an action on 8? Given
I think
the,
the board did the board vote on that? Yeah, I think we're on 9.
we're on 9. Okay, we we're fortunate to have Dana Blakely here, Brevard County Property Appraiser. Wanted to appear before the board. And as far as I'm concerned, you have an open invitation. Anytime you want to speak to us, you know.
I appreciate that, Chair. I normally only come if I have a purpose. I'm always at the organizational meeting and, of course, always at the final meeting. So I'd like to start by remembering everyone deployed wearing red on Friday to recognize Major Brooke Bellman. She is so selflessly serving us overseas voluntarily while we enjoy all the freedoms that we get to enjoy. So I just want to publicly recognize her and tell her that I love her. I'm thinking about her. So the reason I wanted to address the board today is I have some major concerns about some of the things that happened last year with the board, and I have some questions. But I want to be very clear, and I left a packet of information for each of you, one for the board attorney and one for the clerk, to have for the record. And I'm not going to read all of this information to you because most of it is information you either already have or it is simply excerpts from the rules and regulations or statutes that oversee this process. And also, let me say, we are always very appreciative, particularly to our citizen members that voluntarily serve on this board. It is a highly regulated process. It's difficult at times to understand, and so, it's okay that we have a difference of opinion. That's what this process is about. But it's not okay if we feel that the process is not fair for all petitioners. So for folks that haven't served for a long time, like Commissioner Atkinson, Commissioner Altman kind of understands the tax roll process. But just so you understand, property owners can communicate with the property appraiser 365 days a year about their assessments. And as a matter of fact, when the trim notices are mailed, the notice of proposed property taxes, which are going to be mailed on Monday, there's actually a formal 25 days in which the property owner can request an informal meeting with the property appraiser to have this exchange of information. Understand there's no incentive for the property appraiser to appraise a property higher or lower than she feels that the market supports. Budget isn't dependent upon that. There's no scorecard, that type of information. What typically happens during this period of time is an exchange of information. So there are thousands of petitions filed every year. Many of those are resolved through an exchange of information, informal counsel, maybe a formal council meeting, or we are receiving information that we need many times to go ahead and approve an exemption that we previously didn't have enough information to do. So it's not a very adversarial process at that point in time. It only becomes adversarial if we are not able to have that informal conference or we cannot come to an agreement, meaning the property appraiser and the property owner. So then they can, of course, exercise their administrative right of appeal and come before the Value Adjustment Board, meaning magistrates in a county this size, and then eventually have a recommendation and a record of decision based on their appeal. So that's the process in a nutshell. But the first thing that you have is a copy of 1289.005. I'm not going to read everything to you, but I want you to know that the property appraiser's office has to be very, very careful, and the rules specify that personnel performing any of the board's duties have to be independent from the property appraiser and the tax collector. So Chairman Altman, you are correct in that we cannot have any ex parte communications. I can't contact the clerk and say, the process would be better if you did X, Y, and Z. But what I can do is opine on the process or let you know if I feel that the process has some legal pitfalls. And I do feel that we ran into that last year. The next thing that you have is a copy of 194.035. And the reason I'm doing this is because none of you are required to have any training to sit on this board. I disagree with that, but the legislature disagrees with me. The magistrates are required to have training, but in a county this size, the board members are not required to have any training. So you guys are kind of coming into this, I'm not going to say blind, because you do have counsel, you do have a clerk that helps guide you through that process. But in terms of understanding and knowing what the board can and can't do from the onset before it becomes a question to your attorney is kind of difficult. So one of the big differences that we talked about last year, Chairman, is the fact that now, as we sit here today versus years ago, we are required to have magistrates. And that comes with limitations in terms of what the board can and can't do. And the law is very specific about the qualifications of these men and women that are serving in these roles. They are many times state-certified general appraisers, state-certified residential appraisers, and attorneys that have to have a certain amount of experience, and I've kind of highlighted that in that section. Now, last year, And we're fortunate, I think all the members are the same this year from last year, I believe. I could have that, so everybody served last year. So we had a situation last year where we had a case that went before a magistrate, and the evidence was submitted, of course, by the property appraiser and the petitioner, and the request for a reduction was denied. So the petitioner and the petitioner's counsel showed up at a final meeting, and after 56 minutes of testimony and submitting evidence, you guys decided to collectively send it back to the magistrate for another look. And that's not really prescribed by law unless you find that there are legal insufficiencies with the findings of facts or conclusions of law. And specifically, that is really the authority of course, the board, but the VAB attorney is the one that makes sure that all of the recommendations have a finding of fact and conclusion of law that is in accordance with law. And there's 3 particular statutes that are referenced there. So basically, when those recommendations come to the board for a final review of you for you to sign off on those, that should be legally vetted at that point. However, the board had the discretion, so says the VAB attorney, and you guys sent that back. Well, the magistrate came back with not only the same decision, but he enumerated in 2 additional pages why he was not going to make any change in value. Subsequently, you sent it back again with a directive and a number and a value. And so what the magistrate did was enumerated the same information, found the same conclusions, but changed the last paragraph. Now, this process became an issue where the property appraiser lost her constitutional rights to be able to cross-examine any of the witnesses that was giving testimony. We concluded, you as the board concluded that there was not a rehearing, and we have that in the transcript from your attorney that there was not a hearing. There really wasn't anything you could do at that point because any and all testimony and evidence had to have happened at the original hearing. But that's not the outcome. So as a result, I had to file a lawsuit to ensure that the constitutional rights of all other petitioners that didn't have the opportunity to have a request for reconsideration, and even to the point where the board directed the information go back to the magistrate with a number. Now, in 194-034, there are rules of procedure on evidence for all parties. Obviously, there are problems there when you have that the rules of evidence are not followed. Now, I'd like to bring your attention to 194.301, and this is what happens when there's a challenge to an assessment and the presumption is retained or the presumption is overcome. If the presumption of correctness is retained, that means that the property appraiser's value by process is upheld. If the presumption of correctness is not retained, then it is the responsibility of the petitioner by preponderance of the evidence to prove that the value should be changed. And if there's evidence there, if there's a lack of evidence, if you look at B that's highlighted, if the record lacks such evidence, the matter must be remanded back to the property appraiser with appropriate directions from the Value Adjustment Board or the court, and the property appraiser has to comply with those directions. It does not say it is remanded back to the magistrate. It says if the lack of evidence is there, it's remanded back to the property appraiser. That did not happen last year in this case. After that took place, you guys adopted a formal procedure for request for reconsideration. Now, I would say that there's 2 places in the statutes that talk about a request for reconsideration. Those 2 places are in the DOR series. 12D9.032 under final decisions, it says that no reconsideration of a recommended decision shall take place until all parties have been furnished all communications and have been afforded adequate opportunity to respond. Of course, there would have been no way to know that the petitioner was going to show up and give 56 minutes of testimony from his attorney, and that the board attorney said that was not going to be a rehearing. There was no chance for me to have any witness testimony or to cross-examine the information that was being given by the petitioner. The other place in the law that talks about a reconsideration is in the role of the legal counsel to the board. That's in 12D9.009. That says, board legal counsel shall review and respond to written complaints alleging noncompliance with the law by the board, special magistrates, board clerk, or the parties. Legal counsel shall send a copy of the complaint along with the response to the department meaning the Florida Department of Revenue. This section does not refer to routine requests for reconsideration, requests for rescheduling, and pleadings and argument in petitions. Now, I agree with the VAB attorney when he says in his memorandum that we've always had many, many requests for reconsideration. You've just never had a formal procedure for that. And I would agree. Many times petitioners are not happy with the recommendation of the magistrate, particularly when it doesn't vote in their favor or the value conclusion is not what the petitioner is requesting. However, the only recourse at that point is not a request for reconsideration because they're not happy. It is circuit court. All of the forms that the Value Adjustment Board uses, this board and boards all around the state, do not have another step in the process. Requests for reconsideration can be done, and the law specifies it can be done, if in fact the findings of facts or conclusions of law are not found to be within state statute. Not just, I'm not happy with the value. So the new information that you do have there is a legal opinion from my attorney, from Lauren Levy. And there are some things in there that specify, yes, that the board by law can have additional operating procedures, but the law kind of talks about that. It also says that you cannot adopt new rules. You can't expand on them, but you can adopt new operating procedures. I'm not going to read you the opinion. You have it there. But I do want to bring your attention to page 3. The Value Adjustments Board review of special magistrates' recommended decisions are governed by the Florida Administrative Code. It talks about what the Value Adjustment Board attorney must do and what the board must consider when looking at the recommended decisions. But I want to bring your attention to the highlighted section of 3 in the middle of the page. If the board determines that a recommended decision meets the requirements of subsection 1 above, the board shall adopt the recommended decision. When a recommended decision adopted by the board is adopted, it becomes final. So that means that if you do not find that the findings of facts or conclusions of law within a recommendation, if you find that they meet the test of the statute, you must adopt that recommendation. That's what that says. Bar legal insufficiency, because you are required to hire magistrates with a certain amount of expertise, certifications, credential, bar license, those types of things, to ensure that the recommendations that you are getting are sound legally. And if they are found not to be, it is the property appraiser's opinion and the opinion of the law and the court that the Value Adjustment Board attorney performs that function for you. And you as a board can send those back to a magistrate if you find that that is the case. The other thing that I want to bring to your attention is no matter what this board decides to do, I can tell you that I am always going to be an advocate for the property owner. I'm a property rights girl, that's where I fall. So if in fact you're going to proceed and you are comfortable with your new procedure, then there is no way for a petitioner to know that they have that option. It is not on your website. It is not in Axia, where people file petitions. It's not on the clerk's website. You haven't published anything. It's not on the DOR forms. It's not on the recommended decisions that you are going to be sending the petitioners once those recommendations come. And based on your procedure, there's a time limit of how many days someone has in writing to request the reconsideration. So how in the world is any petitioner to know if it's not advertised, it's not in their instructions, it's not on the website, it's not in anything that's publicized, it's not in a publication by the DOR, it's not in any of the forms? How in the world is all petitioners, everyone supposed to know they have that option if they disagree? Okay. So for the property appraiser, this is a question of accuracy, equity, and uniformity. Because that's the world that we live in when we are establishing value conclusions for all properties. So I just wanted to bring that to your attention, and I thank you for your time.
Thank you, Ms. Bickley. General Counsel, I think that being the fact that we're in a possible lawsuit, I think we shouldn't comment up here to give us exposure to anything. I don't know how you feel about that, but I wanted to say thank you for coming out and eloquently laying out your opinions on those items. And
Now, the lawsuit is not with the
Thank you.
board.
I understand.
The lawsuit is with the property owner, because unfortunately, unless you were to do something over and over, consistent violations, I don't have that availability. Even if it is the board that violates my constitutional rights, because it's only one petitioner, I have to file.
You can
against-
come up.
I have to file against the property owner.
Mm-hmm.
Now, I would, so that, I'm not by any means saying you shouldn't discuss something or you should discuss something. I'm just
Yeah.
letting you know that, and that's in there as well.
yeah, I just know that was my theory, and I appreciate you coming with everything. But that's how I felt. That's all I was going to mention. And whatever your feelings are on that, I think I appreciate Ms. Blickley coming forward and saying these things. And I think for us, I don't think we should mention anything. That's all. Discussion.
My 2 cents is that's probably prudent not to discuss
I had a couple
items that may be
things.
subject to litigation, but
I just wanted to, one, I appreciate you being here, what you said. I like the idea of the training. I think this board's seeking that. I would be willing to. It would be very beneficial for us to have some training, some briefing. I don't know who would do that, but maybe that's something we would have some discussion. But I don't know if the Department of Revenue provides that service.
there's board training offered by the DOR each year, so that's voluntary for this board. I'm happy to brief any or all of the board members at any time, before a meeting or otherwise.
Okay,
I was going to say, before the last one, you came to my office and briefed me, so I felt,
right.
yeah, which I appreciate.
I don't have time for
Is a
that.
DOR training, is that something you do online?
It is.
At certain times of the year?
It's available all year long.
Oh,
I
great.
don't remember if the new ones come out yet. They do a new one each year. It does take a while. It's pretty intensive, so.
I'm going to do that. I think it's a great idea. It's a
Mr.
great recommendation.
Mr. Chairman, also, like, I'm in the process right now of putting together the onboarding packet for new school board members. I'm
Right.
updating it right now. Might be, if it's okay with you, if I work with him to develop a packet for new members as they come on for a local educational piece, and then
Heck,
bring
yeah.
that before the board.
Thank you for volunteering for that.
Yeah,
I
that's no
thought you were going to
problem. I'm doing it
volunteer
over
me,
there.
but no, that'd be even better. if
And
you
then,
could do it.
and
That'd be
then,
good.
because the DOR is good, but it's not local specific.
Right.
So if it's okay, I'd like to develop that, maybe bring it back to the next meeting for you guys to review.
That'd be
Tell me what you
good.
think, and then go from there.
And I will do that DOR. I find the DOR to be very helpful and very informative. I'm curious what it's like.
And Chairman, I just want to say for the record, I'm not recommending that the board have training. That
No,
would
that's-
violate. What I'm saying is that the law doesn't require formal training for.
But you
for-
did say you wish it did.
I did say I wish
Yeah.
it did, and I
Yeah.
stand on that.
Yeah. And then, so definitely, I think it's a great idea, and I'd love to do that. It sounds like there were a lot of statutory changes, so they probably haven't updated the training yet to include the new,
I don't think I've gotten an email that it's out yet, but
right? Okay.
I don't take it, so I don't necessarily,
Let
I'm not
us- let us
100%.
know. That'd be good. You did say one thing, though, that I differ a little bit. Well, I differ a lot, I just disagree. When you said that this particular landowner in this petition request was given some sort of favorable treatment, that it wasn't available to everyone, absolutely, that's not true. What we did for that landowner was available to virtually every petitioner to hear their appeal. We don't have any set restrictions on the time. We didn't give them any special treatment at all.
With all due respect, sir, I disagree, and special treatment isn't the right verbiage. I wouldn't characterize it as special treatment. You had no way of knowing, nor did the property appraiser have any way of knowing that property owner was going to show up at the final meeting. I don't even know how long the clerk's office knew. I don't know if he called the day before, got added to the agenda. Not my concern if he did it last minute or if he did it 2 months before. But we had no way of knowing that. And it shouldn't be a problem because at that point in the process, as specified by your attorney on the record, there wasn't anything that you could do at that point by way of listening to additional testimony or taking in any evidence or providing another hearing where even the property appraiser could cross-examine the witness at that point. That time has come and gone at that point in the process. What I am saying to you is that what happened can only be characterized as a request for reconsideration, right? There was reconsideration given. It was sent back to the magistrate, not once but twice, until the board gave a directive on what they wanted. And the magistrate was very specific it had 3 recommendations, and the third one said, based on the Value Adjustment Board's directive, here's what they want, here's the value.
Without getting in, I agree with Matt Susan, we don't need to rehash that, that's going to be litigated.
But the process
But-
itself,
but your
no
point-
other petitioner would have had any way of knowing at all that a request for reconsideration was available. And subsequently, even as we stand here today, okay, even though you now have a formal procedure
But that petitioner had no way of knowing, they didn't know either. I mean, we entered this hearing, we could have had a line, we could have had the room full and a line going around the fountain out there. We didn't have any way of knowing how many people were going to show up, or we're open meeting and
That's
fully
correct.
accessible.
That's correct, sir,
But
because
what-
anybody can show up under public comments, yes.
But are you saying that maybe we should have procedures that if you want to appear before the VAB and present your case, that they give notice, or can anybody just?
No, sir, I wouldn't even answer that question because that would violate the law if I did. You would have to ask your attorney that. I understand what I think
But my
the
point
legal
is, we
answer
gave
is,
no
but-
one any special, it had no idea what this person was going to say or if they were going to come out. We were open to everyone. There was no special treatment given to anybody.
That was not the assertion. That's not the assertion I'm
Okay.
making now, and it's not
All
the
right.
assertion in the formal complaint either, sir. It was a
Okay.
due process constitutionality issue.
All right. I don't know if we've gotten a copy of that. We should take a look at that, too. And
The procedure,
yeah, no, the actual lawsuit.
I'm sure I can find it.
Yeah, we should get briefed on that, so we know what's happening, what the arguments are, and what the allegations are, and that'd be helpful to us. That'd be a learning process in and of itself.
I can send that over.
That would be good.
Question.
Yes.
Sorry. Ms. Blickler.
Dana, just Dana's fine.
Okay,
Yeah.
Dana. You did mention that this property owner got, how was it? Something outside the process happened, right? And it didn't say, even in our website, that was an option open to the taxpayer or the petitioner. Is that right? So my question is, or my request is maybe, that no process is perfect. You can always sharpen the pencil a little more,
Right.
perhaps, a review of the website, because usually the website is very good. I mean, I've seen a lot worse. And perhaps if there's something in there in the process, little fine tuning, a tweak, maybe working with the property appraiser's office, the staff can get together on the right words. No, can't do that?
Can't do that.
No,
No,
not
sir.
doing that.
No, sir.
We don't want to violate the law, I get
No,
it.
sir.
But,
There's a lot that we talked about while we were there in regards to this topic. We actually
Okay.
said that we could email out all of the members that this is an available option for them and stuff like that. I think this briefly brings up some of those comments that we had during that time. I think those are some of those things that we can bring back to make some changes to our process. I agree with you 100%. I would love to have more.
Yeah, just review it.
Absolutely.
Yeah, right. Yeah, it was interesting, we had so few appeals. Maybe that's a good thing, but I assume, as you said, most of these are resolved when they meet with you at the beginning of the process.
Yeah,
They don't-
most of them, Chairman. Unfortunately, this has become a business, okay, all around the state. It is really, really changed from, if you go back to when you and I first started in this process, it was basically property owners and business owners and those seeking classifications and exemptions that were making appeals. Now it's kind of become, not kind of, has become a business. So you do have tax reps that will shotgun, 1,200 residential cases and kind of see what happens. And, for the property appraiser, I have to defend those cases as if they're going to show up. So it is a costly endeavor, not this board's problem. That's something the property appraiser has to do. I can't treat a case as though I feel they may not show up or withdraw. I have to prepare my testimony, my comps, my evidence, supply it to the tax rep on behalf of the property owner as if it is a individual property owner filing on their property. But what I would say to you is, yes, thousands of appeals are made, with or without those additional tax reps that are filing on these cases, and many times that is an exchange of information. Sometimes it's information that we would know, okay, that the market wouldn't tell us. Maybe it's some functional obsolescence on the property. Maybe they had some water damage and now they've got a mold problem and they've got some information that they supply us with. Maybe there's something that's not memorialized in the public records that prohibits development or something. So yes, again, the property appraiser is looking for a reasonable range of value for every property. She's not looking for a value here or a value here. She's looking for a value that we can defend and that is equitable, accurate, and uniform.
I think it goes, it's interesting, what percentage of the appeals are tax reps versus individual homeowners, property owners, business owners?
By volume now, I'm looking over at these ladies, maybe George has 97% by tax
Wow.
reps.
Really?
Yeah,
That's incredible.
yeah.
And I would add that most of the larger ones tend to be tax reps as well, and they take a lot of resources.
Interesting. Well, that's good information. We're sponges up here. We want as much information as we can get.
you're seeing an increase, and you said 90%?
97.
About 97%. Only about 3% of the cases are
Organizations,
not.
right, that are representing the petitioners, I guess? Is
I'm
that
sorry?
right? There are organizations that do this for a living and represent the petitioners, right?
Yes.
So, getting back to the original, do we want to raise the VAB
Yes,
petitioning fee, filing fee, from 15 to 50?
right.
I don't know if we get to share funds, but we'll do our part.
No, sir, I'm not part of that equation. That's between the county commission and the school board to split those costs incurred for the hearings. The property appraiser doesn't have a line item in her budget where she can ask.
VAB costs.
Yeah, correct. I just have to include that in the part where I defend the values that.
Cost of doing business.
Cost of doing business, yes, sir.
Gotcha.
Now, ironically, though, I don't know, but the hearing that we had here was a property owner. It wasn't one of these businesses that have,
And his lawyer.
and his lawyer. But everybody's entitled to get legal counsel and probably recommended a lot of times. But this has been very, very helpful. That I thought about your as we move forward. Okay, 97%. That is a huge. That's shocking.
And they've
Interesting.
dramatically increased in beginning last year throughout the state. At least that's been my observation.
Wonder why. Why do you think it's increased? Do you have any ideas?
It's a business, sir.
It's a way of making money.
It's a way to make money. Yes, sir, it's a business.
How many of those are like, now, of course, if you appeal, and back to the point of the fee, if you appeal and you get relief, you don't have to pay the fee. It gets reimbursed, doesn't it?
No, sir.
No, it doesn't. It used to be that way many decades ago, maybe, but,
I used to not color my hair. Chairman.
Okay.
Yes. Yeah, the filing fee, I believe, has always been the cost of appealing, no matter
Right,
what
no matter what
the
happens.
fee
Yeah.
was. Yes, sir.
okay. I thank you. Thank
Thank
you
you.
so much for being here, and
Thank you for your time.
we welcome your presence and input anytime, and I'm going to make a note to wear red. That's a striking red you have on. Red on Fridays, okay. That's good.
Okay, so we got an action somewhere in here.
Pardon me?
After this presentation, we got an action somewhere, right?
Public comment, and we have board reports.
Yeah, when you say an action.
No, I mean, maybe training set up
Right,
for
that's
the
right.
board.
No, but it's not in reaction to Ms. Blakely, it's just something that we said we would like to do.
Yeah, I think
Fair enough.
that's great input. I think it's great input.
I will forward to the board the training,
Okay,
the link to the
good.
training.
Good. Let me get back to the agenda here. Do we have any member of the public who wishes to be heard? We do not. Okay. Board reports. Number one, Value Adjustment Board Attorney. Do you have any additional?
Thank you, yes. I've got one that's required and one that's just informational. The rule does require us to discuss Florida's property tax system. Ms. Blickley actually covered almost all of what I usually say to do that, so I won't recite what she already did, but the process generally begins with the trim notice, at which point they can have that informal meeting, file a VAB petition, or go straight to court. You can file a lawsuit. You don't have to go to the VAB if you're a taxpayer. After going through the VAB process, which we've covered in various points of today's meeting, again, petitioners or the property appraiser may file suit in the circuit court to appeal the VAB's final decision. And that final decision gets no special weight in the circuit court. It's reviewed de novo, meaning newly, so everybody gets a fresh look. And that's really the very short version of the process as it relates to the VAB. The specific report I have is there is, which is very unusual, there is a pending lawsuit involving the VAB. It was filed by one of the petitioners from last year. I have responded to that. I filed a motion to dismiss. I can tell the board this comes up from time to time. I think it's the second or third one we've had since I've been counsel. The long and short is this petitioner filed it in error. She filed a suit only against the VAB, disagreeing with the outcome of her petition. The proper party to that is the property appraiser. Just like when you appeal in regular court, you don't sue the judge you disagree with on appeal, you sue the other party that you disagree with. So I filed a motion to dismiss on that basis. It should be granted. The hearing is set for the 26th of August. So I will have a report for the board after that hearing, whatever the outcome may be. I did try very hard to communicate with Ms. Velasquez, the plaintiff in that case, and tried to persuade her every way I could that she had filed the lawsuit erroneously, so we did not have to do anything in the litigation. She did not agree, so I was forced to file our motion. It really should be granted. The law is extremely clear.
Did she use an attorney?
No, it's
She
pro
did
se.
not- Oh, wow.
Yeah,
Okay.
yeah. So that is what it is, but unless there is a really significant mistake, the case should be resolved very soon.
Okay.
What's she asking for in the suit?
It's not that clear, and it's really not even that relevant to us, but essentially a reduction in value.
Okay.
Is she able to, if this is thrown out, will she be able to refile it properly, or is it a dead issue?
Probably the court will give her leave to amend, but not to include the Value
I see.
Adjustment Board.
Okay.
That would be my best guess.
Yeah. Okay, it's very interesting.
And that's all I have. Thank you.
Okay. I have no report, other than you're going to send us all those dates. You'll email us, the clerk will, the dates. If
Schedule.
y'all could follow up and email us all the dates, so my staff can get them on the calendar. And the sooner the better.
Yes, sir.
And we can call and request that. Okay, Commissioner Atkinson? School Board Member Susan?
Nope.
Robert Springer?
I have nothing, sir.
Robert Adams?
Nothing, sir.
Okay. Well, I think that concludes our meeting, and thank you for being here. We have unanimous attendance, and thank you, especially for those citizen volunteers for your willingness to serve the public. Really looking forward to the next series of hearings, and I will adjourn the meeting.